The police just told you you're free to go. Those words right there, that exact moment, most people feel a wave of relief wash over them so completely that they're already reaching for their car keys or turning toward the door before the sentence is even fully finished. Free to go. It sounds like the end of something, like a gate swinging open, like the whole encounter just closed itself, and now you can walk away and never think about it again. And in a lot of situations, that's exactly what it is. A clean ending to something that started tense and finished fine. If you've got a specific legal question or situation you'd like to see covered here, drop it in the comments, because that's genuinely where a lot of future topics come from. I read them, and some of the most useful specific videos on this channel started as exactly that kind of comment from someone dealing with a real situation, so don't hesitate. Whatever it is, I'd like to hear it. All right, let's keep moving. But here's what nobody tells you, and what almost every person in that moment gets completely wrong, not because they're careless or uninformed, but because nothing in the way that phrase sounds prepares you for what it actually means legally. You're free to go is not always the end of the conversation. It is sometimes the beginning of the most consequential 30 seconds of the entire encounter, and the single question you ask right before you walk away, or don't ask, can determine whether you leave that situation with your rights fully intact, or whether you quietly hand something over without ever realizing you had the option to keep it. Before we get into exactly what that question is and why it matters so much, if you want to actually understand what's happening in these moments, instead of guessing and hoping things work out, subscribe right now, because this is exactly the kind of scenario we walk through here. Real situations, real legal framework, no vague reassurances, just the clearest possible picture of what your rights actually look like when they're being tested in real time. Quick note before we go further, this is legal education and commentary, not legal advice for your specific situation, and some details vary state to state, but the core framework we're going to walk through holds up across virtually the entire country. Let's get into it. Let's start with what "you're free to go" actually means, because the phrase carries a specific legal weight that most people don't know about, and that weight is the reason one particular follow-up question changes everything. When a police officer tells you that you're free to go, what they're legally establishing, whether they mean to or not, whether you understand it or not, is that the detention is over. Up until that moment, if you were being detained, meaning you weren't free to simply walk away on your own terms, the encounter operated under a particular set of rules. The officer had some level of reasonable suspicion, or another legal justification that was holding the interaction together. But the moment those words are spoken, that legal framework shifts, the detention ends, and what replaces it is something entirely different, a voluntary encounter. This is the part worth sitting with for a moment, because the difference between a detention and a voluntary encounter is not small. It's one of the most significant distinctions in the entire body of law that governs police interactions with ordinary people. During a detention, your choices about what to do next are limited by the fact that you're not free to leave. During a voluntary encounter, by definition, you are free to leave, and everything that happens after that point only happens because you chose to stay and participate. And choosing to stay and participate, even for 30 more seconds. I want to talk for a second about why I think content like this actually matters, beyond just being interesting to talk about. There's a real meaningful gap between people who have easy access to legal knowledge, whether through education, profession, or family background, and people who don't, and that gap has real consequences in real situations. It's not fair, and it's not something any individual video is going to fully fix, but I do think there's genuine value in narrowing that gap even a little, one plain language explanation at a time, for anyone willing to spend a few minutes actually learning something instead of relying on guesswork or half-remembered fragments picked up secondhand. That's the actual mission behind this, as unglamorous as that sounds, not to turn anyone into a lawyer, but to close the specific, practical gaps that leave ordinary people at a disadvantage in moments that matter. All right, let's keep working on exactly that with today's topic. Seconds, even to answer one more question, even to let someone look at something you're holding. That choice, made without fully understanding what it means, can produce legal consequences that have nothing to do with whether you did anything wrong. This is the architecture underneath the entire conversation we're about to have. Hold on to it, because it's the reason the one question we're building toward matters as much as it does. Now, before we get to that question, let's talk about what typically leads up to the moment where "you're free to go" gets said, because the context matters, and it shapes which version of this scenario you're actually in. The most common situation is a traffic stop. You get pulled over for something, a moving violation, a broken taillight, maybe nothing more than being on a particular road at a particular time in a particular kind of car. The officer asks for your license and registration, runs your information, and after several minutes, which can feel much longer than they actually are, comes back to your window and says, "Everything checks out, you're free to go." That's the clean version, and it's genuinely clean. No further questions, no request to search, no ambiguity. You take your documents back and you leave. That scenario doesn't need what we're about to talk about. But there's another version that looks almost identical from the outside and plays out very differently from the inside, and this is the version that matters for this video. The officer comes back to the window, returns your documents, says you're free to go, and then, in the same breath, or in the 2 to 3 seconds immediately following it, adds something else. "Hey, before you go, you mind if I just take a quick look in your car?" Or, "Actually, while I have you, do you have anything in the vehicle I should know about?" Or, sometimes it's even softer than that, more casual, almost offhand. "You don't have anything in there I need to worry about, right?" That pivot, right there. That is the moment this entire video is about. Because what just happened, legally, is something very specific. The officer told you the detention was over, establishing, by design, that anything you agree to from that point forward is voluntary and consensual, and then immediately used that voluntary consensual framework to ask for something they couldn't compel you to give during the detention itself. This is a recognized and widely used tactic, and understanding it doesn't make the officer using it villainous. It's a legal technique, it works within the rules as they exist, and courts have generally upheld its use. But understanding it does give you the ability to respond to it in a way that actually reflects what you want to do, rather than what you feel pressured to do in a moment, specifically designed to catch you slightly off guard. So here is the one question you ask before you do anything else, when you're free to go, is followed by a request of any kind. Am I free to go, or are you asking me to stay? That's it. That single sentence. 7 words that clarify, immediately, what kind of encounter you're now actually in. Let's talk about why this question does what it does, because it's worth understanding the mechanism here, not just the result. When you ask, "Am I free to go?" or "Are you asking me to stay?" you are forcing an explicit answer to a question that the ambiguity of the situation was specifically relying on you not asking. You're cutting through the casual tone, the friendly framing, the "this will only take a second" energy that surrounds that pivot moment, and you're asking the officer to tell you plainly, on the record, which legal category the next 30 seconds falls into. If they say you're free to go, meaning they're not asking you to stay, this is completely optional, then you have a clean answer. You know exactly where you stand, and from that point, you can make a genuinely informed decision about whether to stay and answer questions or consent to a search, rather than a decision made in a fog of assumed obligation. Most people, when they understand that they're genuinely free to leave and that staying is a purely voluntary choice, make a different decision than they would have made if they thought they had to stay. And that difference, that actual, informed, uncoerced choice, is the whole point. If they say they're asking you to stay, or if they suddenly shift tone and tell you that actually they need you to remain for a bit longer, you've learned something extremely important. The detention hasn't actually ended, or a new detention is beginning, and that detention requires its own justification. And that justification, reasonable articulable suspicion of criminal activity, is something they either have or they don't, and the question of whether they have it is something an attorney can examine later, not something you need to debate on the roadside in the moment. Let's talk about the follow-up to this question, because the question itself is step 1, and knowing what to do with each possible answer is step 2. And step 2 is where most people who know step 1 still stumble. If the answer confirms that you are genuinely free to go, the request is completely optional, they're just asking, then the next thing you say is simple, clear, and complete. "I appreciate it, but I'd prefer not to, and I'm going to go ahead and head out." That's the whole sentence. Warm, clear, final. You're not explaining yourself. You're not apologizing for your preference. You're not offering an alternative or a compromise. You're simply exercising the choice that the voluntary nature of the encounter gives you, fully and cleanly. I want to pause here specifically on the not explaining yourself part, because this is where people trip up almost every time, even people who know they have the right to decline, even people who've thought about this before. The moment you feel free to go, and someone asks you a question anyway, there is a deep, genuinely powerful social instinct to justify your answer. To explain why you'd prefer not to make sure the officer understands you're not refusing because of anything suspicious, to say, it's nothing personal, or I just have somewhere to be, or I don't have anything in there. I just don't really like searches generally, you know? And every single one of those explanations, well-intentioned as they are, does something you don't want it to do. It keeps you there. It extends the conversation. It gives the interaction more surface area than it needs to have. It invites follow-up. And sometimes, in a specific kind of situation, an explanation that you volunteered voluntarily can become part of a longer conversation that ends somewhere you didn't intend to go when you started talking. The clean version, I'd prefer not to, and I'm going to head out, is not just legally cleaner, it's practically cleaner. It closes the conversation instead of reopening it. And it's not rude, it's not hostile, it's just complete. Now let's talk about something that happens immediately after you say you'd prefer to go, because this is where a second moment of pressure often appears, and it's almost always some version of the same thing. Well, if you don't have anything to hide, why wouldn't you let me take a look? Or, you seem nervous. Why are you nervous if there's nothing in there? Or sometimes just a long, deliberate pause and a look, the kind that creates its own pressure without saying anything specific at all. These responses are not evidence of anything legal. They're social pressure, and social pressure, however uncomfortable it feels standing next to your car on the side of a road with someone in a uniform looking at you, is not a legal obligation. It does not override your right to decline. It is not something you're required to respond to or explain. I understand, and I still prefer not to, is the only sentence you need here, and you can say it as warmly as you want without it losing a single thing. You've made your decision. The explanation for your decision lives with you and your attorney, if it ever becomes relevant, not on the roadside with a stranger right now. Let's talk about what's actually happening on the officer's side of this interaction, because understanding it makes the whole thing easier to navigate without feeling like you're being paranoid or adversarial. The ask after you're free to go approach is used specifically because consent obtained under genuinely voluntary conditions is cleaner legally than consent obtained during a detention, where there can be questions about whether the person really felt free to say no. By explicitly ending the detention first, by saying you're free to go, and then immediately asking for consent, the officer creates a situation where any consent you give afterward is very likely to be upheld as genuinely voluntary, if it's ever challenged in court later. It's a well-understood technique, it's been reviewed by courts many times, and it exists because consent searches that hold up legally are significantly more useful in a prosecution than consent searches where there's room to argue the person didn't feel free to refuse. Understanding this isn't about assuming bad faith. Most officers who use this approach are simply doing what they've been trained to do, working within a legal framework that allows this kind of encounter. But knowing why it's structured this way is exactly what puts you in a position to respond to it clearly, because now you understand that the entire architecture of that moment is built on your voluntary participation, and voluntary participation is something you can decline. Let's talk about the version of this that happens outside of a traffic stop, because you're free to go, followed by an immediate ask, doesn't only happen on roadsides. It happens on sidewalks, in parking lots, outside of buildings, in train stations, in airports, in all kinds of public places where police might approach someone, conduct a brief stop or investigative contact, and then attempt to extend that contact into a voluntary encounter the moment the initial legal justification for the stop starts to thin out. The same framework applies, and the same question does the same work. Am I free to go, or are you asking me to stay? Clarifies whether the stop is ongoing or whether you've entered voluntary territory. And once you're in voluntary territory, the same clean close applies. I appreciate it, I prefer not to, I'm going to head out. The setting changes. The underlying logic doesn't. Let's also talk about the version that happens when you're not the subject of an investigation at all. When officers approach you in a public place and it quickly becomes clear they're looking for information about something or someone else, asking if you saw anything, if you know anybody in the area, if you recognized a description they give you. This starts as what's called a consensual encounter from the very beginning, meaning there was never a detention, and you've always been free to go. The same principle applies here, just without the "you're free to go" transition, because you were always free to go. I don't have anything I'd like to share right now, but thank you is a complete response, requires no further elaboration, and is not obstruction, not suspicious, not a problem of any kind. Let's talk about searches specifically, because the "can I take a quick look" version of the post free to go ask is the one with the most direct and concrete consequences, and it deserves its own careful walkthrough. A consent search is a search that happens because you agreed to let it happen. No warrant needed, no probable cause needed, no reasonable articulable suspicion needed, just your yes. And because your yes is the entire legal foundation for the search, what you consent to, and how broadly or narrowly you define it, matters in ways that people almost never think through in the moment. Consent to a search can be limited. This is something that surprises people who assume it's all or nothing, that either you say yes to everything or you say no to everything, and there's nothing in between. But the law doesn't work that way. If you choose to consent to any part of a search, you can define the scope of that consent yourself. "You can look in the trunk, but not anywhere else" is a legal, binding limitation on the scope of a consent search. "You can see what's in the back seat" is a limitation. "You can look in the glove compartment" is a limitation. These limitations don't guarantee that officers will stay within them, and if they step outside the scope of what you actually consented to, that's a separate legal question that an attorney needs to examine, but they establish the record of what you actually agreed to, which is everything if a challenge to the search ever comes up later. More practically, if you've decided that the right answer for you is to decline the search entirely, which is your right, you decline entirely. "I'd prefer not to consent to a search" is complete. But if you're ever in a situation where you've chosen to give limited consent for some reason, know that the limitation you set is real, and it matters, and state it clearly enough that it would be captured by any recording of the encounter. Let's talk about something connected to this that people ask about constantly, because it's one of the most emotionally loaded parts of this whole topic. What if you truly have nothing in your car, nothing to hide, nothing that could possibly cause a problem? Is there still a reason to decline a search? Yes. And the reason isn't about what's actually in your car. The reason is about what you know is in your car versus what a search might find, interpret, or create a question about, and the difference between those two things is larger and more unpredictable than most people think. You know your car doesn't have anything illegal in it. You might not know that the person who borrowed your car last week left something in the side pocket of the back door. You might not know that something perfectly innocent in your car, a legally owned firearm, a prescription bottle, a set of tools, loose cash, looks different to a trained eye than it looks to you. You might not know that something that is perfectly legal where you are was illegal somewhere you drove through. You might not know that the smell of something a previous car owner left embedded in the upholstery creates a perception that has nothing to do with you. These aren't paranoid hypotheticals. They're the kinds of complications that turn an "I have nothing to hide" situation into an hours-long roadside ordeal that eventually gets resolved in your favor, but only after a great deal of unpleasantness that you had the right to simply not participate in. Declining a search is not a statement about what's in your car. It's a statement about who decides whether a search of your property is justified, and that statement is that you'd prefer a neutral judge with actual evidence make that decision, not a voluntary agreement made under the social pressure of being asked by a uniformed officer on the side of a road. Let's talk about the K9 situation, because it comes up in this context often enough to deserve specific attention. If you've declined a search and the officer says they're going to bring a dog around the car, or if one appears, understand that the law around this is specific and has been refined through several Supreme Court decisions over the years. And the short version is this: an officer cannot extend an otherwise completed traffic stop to wait for a drug dog simply because you declined a consent search. If the stop is over, if you've been told you're free to go, detaining you further to run a dog requires its own independent legal justification. The "you're free to go" moment, and then your immediate and clear "I'd prefer not to consent and I'm going to head out" matters here, because it establishes clearly that the stop had concluded, which makes any extension of it to accommodate a dog search something that needs its own justification. This is also one of the reasons being clear and prompt about exercising your right to leave matters. Not frantic, not argumentative, just clear and prompt. If you're told you're free to go, and you ask your clarifying question and confirm it's voluntary, and say you're going to head out, do that. Don't linger. Don't wait around asking follow-up questions. Don't stay in the conversation longer than the conversation requires. The moment the stop ends, your behavior should reflect that understanding. Calmly, clearly, without drama. Let's talk about a version of this that doesn't involve a search at all, because "can I take a quick look" is only one of the things that sometimes follow "you're free to go." The other common one is just more questions. "Hey, before you take off, Where are you headed tonight? You don't mind if I just ask you a couple of quick things, do you? While I have you here, there's just something I wanted to follow up on. These questions, offered after you've been told you're free to go, are voluntary. Full stop. You are under no obligation to answer them. You are not required to disclose where you're headed. You're not required to explain your plans. You're not required to give any account of yourself to someone who just told you that you're free to go. The polite decline here is exactly as clean as the one for the search. I appreciate it, but I'd rather not get into that, and I'm going to head out. Warm, clear, complete. There's an important underlying principle here that's worth naming directly, because it runs through all of these situations and it's easy to lose sight of when you're actually in the middle of one. The voluntariness of a voluntary encounter only means anything if you actually exercise the voluntary part. If every single person who's told they're free to go then stays and answers questions and consents to searches because the social pressure of the moment makes declining feel worse than complying, the voluntary encounter isn't really voluntary in any meaningful sense. It's just detention with better manners. The protection only works if the people it's designed to protect actually use it. And using it, consistently and calmly, is not paranoid, not hostile, not suspicious, and not unusual. It is precisely what the legal framework anticipates and allows for. Let's talk about what happens if you feel like the stop has ended, but you're not entirely sure. If the officer hasn't explicitly said, "You're free to go," but has also stopped talking, handed back your documents, and seems to be waiting for something. This ambiguous middle moment is worth addressing specifically, because it's where a lot of people make an unforced error. In this situation, you ask directly, "Am I free to go?" Just those 5 words. Clear and polite. You're not accusing anyone of anything. You're not being difficult. You're simply asking for clarification on the status of the encounter, which is information you're entirely entitled to have, and which eliminates the ambiguity that might otherwise lead you to stay longer than you needed to, or to respond to things as though they were obligations when they weren't. Am I free to go? Is not a challenge. It's a question, and the answer to it tells you everything you need to know about what comes next. If the answer is yes, you use the framework we've already walked through. If the answer is no, you've just learned that the stop is ongoing, which means there's still some claimed legal basis for your presence there, and your rights during an active detention are worth understanding too, including your right to decline to answer questions beyond identifying yourself in states where that's required, your right to decline consent to a search, and your right to have an attorney present before any substantive questioning. Let's talk about the identification piece specifically, because it's a place where the rules vary enough by state that it's worth flagging clearly. Some states have what are called stop and identify laws, which require you to identify yourself, give your name, and sometimes other basic identifying information, to an officer who has reasonable suspicion to detain you. Other states don't have this requirement. In a traffic stop context, you're almost universally required to provide your driver's license, registration, and proof of insurance. But beyond that baseline identification, whether you're required to answer further questions, where you're going, who you've been with, what you've been doing, depends heavily on the specific laws of your state. And in most states, the answer is that you're not required to answer those questions even during an active stop. And you are certainly not required to answer them during a voluntary encounter that's been explicitly flagged as voluntary. Knowing your specific state's rules on this in advance is worth the 15 minutes it takes to look it up, because it converts a scenario that might otherwise feel legally murky into something you can navigate with actual confidence, rather than a general sense that you probably don't have to answer, but you're not entirely sure, and the uncertainty is making you more likely to just answer anyway. Let's talk about the recording question, because it belongs in any thorough conversation about police encounters, and the "you're free to go" moment is no exception. In most places in this country, you are allowed to record an encounter with police in a public place, including a traffic stop, as long as you're not physically interfering with what the officer is doing. A recording that captures the exact words used, the exact sequence of events, who said what and when, that recording is one of the most valuable possible pieces of evidence if anything about the encounter is ever disputed later. It also tends to have a moderating effect on the interaction in real time, not because it turns a legitimate encounter into a confrontation, but because both parties know that the record of exactly what happened is being preserved objectively. If you're in a traffic stop and you've decided to record, do it openly rather than covertly where possible, because the optics of an openly held phone are different from a hidden recording device, and you're not trying to trap anyone. You're trying to document an interaction you're legally allowed to document. I'm going to record this, is that all right, is a courtesy, not a requirement, but it's a courtesy that tends to set a professional tone for the rest of the encounter in a way that usually benefits you. Let's talk about something that sounds like a small detail, but turns out to matter more than people expect. What to do in the minutes right after the encounter ends, whether it ended cleanly or whether it ended with some version of continued pressure or an extended conversation you weren't entirely sure about. Write it down, or if you're still sitting in your car, speak it into your phone as a voice memo right now, before you pull away. The time, the location, badge numbers or car numbers if you caught them. The exact words, as close as you can remember them, including what was said right around the "you're free to go" moment. Was there an immediate follow-up ask? Was there a pause? Were documents returned before or after the request? What was the exact wording of the request? "Can I take a look?" versus "I'd like to search your vehicle," versus "You don't mind if I just check real quick?" Because these variations matter in a legal context, and your memory of the precise phrasing is going to be clearer right now than it will be in 3 hours or 3 days. This contemporaneous note isn't about being litigious. It's about having an accurate record that belongs to you, that exists independently of any official report filed from the other side of the encounter, and that gives any attorney you ever speak to the most complete possible picture of exactly what happened. Notes taken immediately after the fact carry real weight, and the 2 minutes they take to make are almost always worth it. Let's talk about a scenario that's closely related to the core topic but deserves its own specific walkthrough. What happens when you're a passenger in someone else's car that gets stopped, and the "you're free to go" moment applies specifically to the driver, but you're still sitting there? As a passenger in a traffic stop, your situation is somewhat different from the driver's. You generally have your own Fourth Amendment rights in the vehicle that don't evaporate just because you're not the one behind the wheel. If the stop ends and the driver is told they're free to go, and an officer then asks the driver for consent to search the vehicle, your voice also matters. You can state clearly and calmly that you don't consent to a search of the vehicle either, particularly with respect to any area where you have a reasonable expectation of privacy, like a bag that belongs to you, luggage in the trunk that's yours, anything you specifically brought with you. Passengers also have the right to ask, "Am I free to go?" independently of the driver. If an officer addresses you specifically as a passenger and starts asking you questions, you're right to decline those questions, to say, "I'd prefer not to answer questions, and if I'm free to go, I'm going to do that," belongs to you personally, not to the driver, and doesn't depend on what the driver chooses to do. In many stops, passengers are completely free to go while a driver's documentation is still being processed, and knowing that you can ask that question specifically, as the passenger, is worth having ready. Let's talk about the version of this that plays out in your home rather than in your car, because while the specific triggering phrase is most common in traffic stop contexts, the underlying principle, that a voluntary encounter means something very specific and that your participation in it is a genuine choice, applies equally to encounters at your door. If officers have knocked, spoken with you, been told that you're not consenting to entry, and are now preparing to leave, but pause on the way out with something like, "Hey, one more thing, you mind if I just take a quick look around while I'm here?" That exact same pivot is happening in a home context, and it works the same way. "I still don't consent to entry or a search, but I appreciate you stopping by," is your clean close, same framework, same clarity. The location changes, the architecture doesn't. Let's talk about something that I want to be direct about, because sometimes in conversations about rights, people assume that knowing and exercising your rights is primarily useful if you've done something wrong, and that if you haven't done anything wrong, none of this matters because everything will work out fine anyway. This assumption is incorrect, and it's worth being specific about why. Innocent people's lives get complicated by consent searches all the time. Innocent people spend hours on roadsides, miss flights, miss appointments, miss their children's events, because they said yes to something they didn't have to say yes to. And while they ultimately weren't charged with anything because there was nothing to charge them with, the experience of the search itself was genuinely harmful to them and their day, and sometimes to their property, because searches are not clean or gentle processes. They're physical examinations of your belongings conducted by someone other than you, and they can leave things not quite the way you had them. The fact that the outcome was fine doesn't mean the experience was fine, and you had the right to decline the whole thing. Beyond the immediate experience, there are also situations where innocent people, genuinely, Completely innocent people get tangled up in something because something in their car or in their home created the appearance of a problem even though no actual problem existed. Situations where the nothing to hide assumption turned out to be an assumption about a situation they understood differently than the officer examining it did. Situations where a legal item, a legal activity, a legal choice they had made about something in their life created a question mark that then had to be resolved, slowly, expensively, stressfully, through a process that could have been avoided if the search had simply not happened in the first place. Your right to decline a search exists specifically so that the question of whether your property should be searched is answered by a judge reviewing evidence and issuing a warrant, not by your feeling of social pressure in a moment specifically designed to produce cooperation. Using that right is not suspicious. It is not hostile. It is not something you should feel you need to explain or apologize for. It is a protection built specifically for you, available specifically for moments like this one, and the only thing you have to do to benefit from it is use it. Let's talk about how to actually prepare for a moment like this, because preparation is what converts a moment of potential panic into a moment of calm clarity, and the gap between those two versions of the same moment is enormous. Say the questions and sentences out loud right now. Not in your head, actually out loud. Am I free to go, or are you asking me to stay? Say it. I'd prefer not to consent to a search, thank you. Say it. I appreciate it, but I'd rather not answer questions right now, and I'm going to head out. Say it. Hearing yourself say these things, in the calm of your kitchen or your car parked safely somewhere, makes them feel natural, in a way that they won't feel if the first time you've ever heard yourself say them is the moment you're trying to say them, with someone in a uniform standing 8 inches from your window. The rehearsal matters. It's not dramatic. It's not paranoid. It's not about expecting trouble. It's about being the version of yourself that's prepared to handle something clearly and calmly if it ever arrives, rather than the version improvising under pressure. The mental model worth carrying with you is this: you're free to go means the encounter ends unless you choose to continue it. Any continuation from that point is a choice you're making voluntarily, and you can always choose not to make it. The question, am I free to go, or are you asking me to stay, is the tool that makes that reality explicit, so that whatever you do next is something you decided to do with full knowledge of what it was, not something that happened to you because the moment moved faster than your understanding of it. Let's talk about what it actually feels like to be in this moment, because this is where the gap between knowing something and doing something lives, and it's worth naming directly. Even when you know exactly what your rights are, even when you've thought about this before, even when you've said the sentences out loud in your kitchen, when you're actually sitting in your car on the side of a road, late at night or in the middle of a busy highway, with a uniformed officer at your window, and other cars passing, and your hands on the steering wheel, and the flashing lights in your mirrors, the social pressure is real. The discomfort is real. The instinct to just cooperate, to make this easier, to seem like a reasonable person who has nothing to hide, to avoid the awkwardness of saying no. That instinct is completely human, and it is powerful, and it is specifically what these techniques are designed to work with. Knowing this in advance doesn't eliminate the discomfort. It gives you something to hold on to through the discomfort, which is different. The discomfort is the price of the moment. The protection on the other side of the discomfort is what makes it worth paying. And the cleaner and simpler you keep your response, the shorter the uncomfortable moment actually is. I'd prefer not to consent, and I'm going to head out. That sentence ends the moment. The explanation, the justification, the attempt to manage how you seem, those are the things that extend it. Let's talk about what happens if you asked your clarifying question and you got a clear answer that you're free to go, and you said you were going to leave, and the officer acknowledged it, and then continued talking to you anyway. What do you do when the conversation is over by your own clear statement, but the other person keeps going? You stay calm. You don't match the escalation, if there is any. You don't argue, and if you're in your car and the path in front of you is clear, you can slowly, carefully, without sudden movements, put your car in drive. You have stated clearly that you are leaving. That statement was made in response to confirmation that you were free to go. Leaving at that point is not a crime. It is not obstruction. It is not flight. It is exactly what you said you were going to do, which is exactly what the officer confirmed you were free to do. You don't have to wait for a second permission. You don't have to ask again. You said you were going to go, and you go. If anything about that moment feels complicated or like it didn't go cleanly, that's exactly what your contemporaneous notes are for. Write down what happened, in sequence, as soon as you're safely away from the scene. And if anything about what happened feels legally significant, that's what an attorney is for. Let's bring together everything we've walked through, because I want it sitting clearly in your mind before we close, in the kind of order you can actually follow in real time if this moment ever comes for you. You hear you're free to go. Your first move is not to immediately start leaving, and not to immediately start responding to whatever follows it. Your first move is the question, am I free to go, or are you asking me to stay? This question is polite, clear, specific, and it does more work in fewer words than anything else you could say in that moment. If the answer confirms you're free to go, and what follows is completely optional, your response to any request, search, questions, anything, is, I'd prefer not to, and I'm going to head out. Not an explanation, not an apology, not a justification, just that sentence, warm, clear, final. If the answer suggests you're not actually free to go, that there's something ongoing that requires you to stay, you've learned that the stop has continued, and you respond to the rest of it with that understanding, which means your right to decline answering questions, your right to decline consent to a search, and your right to have legal counsel before substantive questioning are all still fully in play. After the encounter ends, make notes. Location, time, badge information if you have it, exact words you can remember from the key moments, the sequence of events as clearly as you can reconstruct it. And throughout all of this, through the question and the response, and the gentle, warm, firm decline, and the clean exit, you remain exactly what you want to be in every one of these situations. Calm, polite, clear, and completely in possession of the choice that was always, legally, yours to make. Let's say the key sentence one more time, out loud, because the repetition matters. Am I free to go, or are you asking me to stay? 7 words. Polite, clear, specific. The single question that cuts through the ambiguity of a moment, designed to work by ambiguity, and hands the clarity back to you where it belongs. You can walk out of every encounter like this knowing exactly what you agreed to and exactly what you declined, because you asked the one question that made the difference between those two things visible. That's the goal. That's what preparation looks like. And the version of you that knows this, that has said these sentences out loud, that has thought through these moments in advance, that version of you walks away from a situation like this, with your rights fully intact, your choices genuinely yours, and not a single thing given away that you didn't choose to give. If this is the kind of clarity you want to have for more of the situations that ordinary people encounter in real life without any preparation or framework for handling them, subscribe right now, because this is exactly what we do here. One real scenario at a time, the framework behind it, and the specific words you can use when you actually need them. Stay calm, ask the question, and remember, free to go is only meaningful if you actually go, on your own terms, with your own rights fully in your hands where they've always belonged. All right, that's where we'll leave it for today. I hope this gave you something genuinely useful, not just interesting to hear, but something you could actually use if the right situation ever came up. That's always the real goal here. Understanding you can actually carry with you, not just information you forget by tomorrow. Take care of yourself, know what's actually yours, and I'll see you in the next one.